Welcome to our Gilfix webinar. So this is a critical topic. Is your trust a ticking time bomb? You might think, well, I have a living trust. I'm good. Wrong. It could be literally could be a ticking time bomb just waiting to explode. And that's the problem with estate planning. You don't know if there's a problem until the documents are needed, either when you're incapacitated or after you're gone. It's very hard to know ahead of time. Of course, if you haven't already done it, subscribe to our Gilfix Law YouTube channel. We're over 60,000 views now of our little videos. So we're very proud of that. It's growing every day. So stay tuned for more there. Subscribe if you haven't. But now, why are you here today? I want you to take a moment just to ask yourself, did you create an estate plan years ago or even fairly recently? Do you even understand your trust structure? Do you understand the dangers of the wrong trust structure? Are you worried that your trust is a ticking time bomb? Well, we're going to go through the critical steps that you can take to protect your assets and your family, and really what you need to know about all of this, because there's no reason you as a normal human, non-lawyer, would understand these issues. That's what I'm here for. That's what our Gilfix and the Bull team is here for. And I think the key here is you don't need to understand everything that I'm going to talk about here today. I want you to just understand what you don't know. You don't know what you don't know, right? It's my mission to make you get your head out of the sand. I don't want you to be this guy. And I think that's the vast majority of people in America. Their heads are in the sand. They just think things will work out. News for you. If your estate plan's not up to date, if you don't have the right tools in place, it's not just going to work out. So what are we going to cover here today in this talk? The 4 major mistakes that people make, that families make, that make it so their living trust can indeed be ticking time bombs. So the first big mistake, having the wrong trust structure. I'm going to spend a lot of time on this. It's kind of a little bit confusing, but I'm going to try to break it down in very plain English. The costly consequences, this is really for married couples, of having the wrong trust structure, an AB or a non-AB. Different structures are right for different families. I'm going to go through what those situations are, and you can then see, hey, which side do I fit in? 2, failure to safeguard your heirs. A living trust does not protect assets for future generations. It does not protect assets from property tax increases. I'm going to talk about what we can do to protect for future generations, your kids, your grandkids, even your great-grandkids. 3, a failure to plan for special needs. If you've worked with us before, you know we are very, very devoted to special needs planning. We've helped hundreds of families in that area, but so many people are ignorant. And this might not be you, but there might be someone in your circle who has a child with a disability, and they might think, oh, I have a living trust, I'm fine. Wrong. You need to take other steps to protect a child or a loved one with a disability. 4, this is a huge one, failure to update. What does that mean? Just you might have set up a set of documents years ago. I'm good. I set up an estate plan. I did what my lawyer said. I'm fine. Wrong. You have to address it every few years, or anytime there's a change in your family, or anytime there's a change in law that you're not sure about. And I'll give a couple examples of how that can really be problematic. And then I'm going to give you some action steps to protect your assets and, of course, to protect your family. Always have to remind that this is just for educational purposes only. It's not legal advice. It doesn't create an attorney-client relationship. We have to meet with you in person and actually get an engagement agreement into place to do that. So don't try this at home. But I do hope this empowers you. And again, if you get something out of this, please spread the word, leave comments, leave questions. We want to reach as many people as we can, because we know there's so much ignorance out there, and there's so much we can do to protect all that you have. So just for those of you who don't really know us, I'm just take a moment introducing our firm. We are Gilfix and Lepole Associates. Very proud of our heritage. We're national leaders in the fields of elder law, estate planning, and associated tax planning. We've been in Palo Alto for over 40 years. I think we're celebrating our 40th anniversary this year. That's crazy. Obviously, I wasn't there from the inception. I was more like that guy. And in fact, that is me in that photo. That's me and my grandfather, my step-grandmother, and my mom. We're a multi-generational firm. It's not just Gilfix people. We have Francis Lepole, extraordinary tax attorney. We have other attorneys as well. We serve thousands of families throughout the state of California, and our goal is to provide extraordinary value and peace of mind. I think we can provide return on investment that's pretty much unmatched in most areas. We've been featured in the national media. I'm on the radio all the time. I've been on TV before about this stuff. I love spreading the words. I love speaking about these issues, as you might be able to tell from these talks. Okay, let's jump in. Is your trust a ticking time bomb? What is mistake number 1? Having the wrong trust structure. The costly consequences of an AB versus a non-AB trust. This is for couples. Now, I want to start with a little tale, a tale of fixing a trust. This should hopefully help you understand these points. So Larry and Susan have a $3 million estate, including their home. So hey, in California, that might just be a house and a retirement account. Susan outlives Larry by 5 years. And by the time she passes away, when assets go to their kids, their estate grows to $5 million in value. Because of the structure of their estate plan, their children face over $300,000 in capital gains tax exposure. Wyatt and Jane, same situation, $3 million estate, including their home. Jane outlives Wyatt by 5 years, same thing. Estate also grows to $5 million, but because of a change they made to their trust structure, their children face zero capital gains tax exposure when their children inherit assets. So that's a difference of $300,000 in potential taxes just from changing their trust structure. I'll go through what that means. And just another example, another tale, a tale of fixing a trust, a larger estate. So Ben and Ann have a $10 million estate. They've done very well. They've invested well. By the time that they pass away, if the second spouse passes away, I should say, it's grown to 18 million. They invested well. Their estate ends up facing over $1 million in estate taxes. $1 million check has to be written to the IRS when they pass, before assets go to their kids. Jacob and Sarah, same situation, $10 million estate. Their estate also grows to $18 million by the time they pass away, but because they made some changes to their living trust structure, zero estate tax exposure. What's the mystery? I'm going to uncover these mysteries in just a little bit. Now, before I uncover these mysteries, I'm going to take just a moment to introduce you or reintroduce you to a couple of really important concepts when we're talking about estate planning. One is the stepped up basis. So let me know if you're familiar with capital gains taxes. You can raise your hand, or are you confused about capital gains taxes? Maybe raise your hand. You don't have to actually, I can't see you. I'll imagine you raising your hand for those of you who aren't quite sure. So capital gains taxes, say you have a share of Google stock, you bought it. I see some people raising their hands. You bought it $50 a share. Now it's worth $100 a share. If you sell it, you have to report to the IRS. Well, I paid 50, I sold it for 100. I made 50 bucks on that. That's your capital gain. Depending on how long you held it, you have to pay either short or long-term capital gains tax on that. It can be a punishing tax. It can be 30 or even 40% in some cases if it's a short-term tax. Huge punishing tax. Now, here's the key concept you have to understand. A lot of people are confused about this. Everything in your taxable estate when you pass away, my taxable, so anything that you own when you pass away, it's a stepped up basis. This means that the IRS says, hey, if dad bought Google stock for 50 a share and now it's worth 100, if it was worth 100 when he passed away and then it goes to his kids, kids only have to report, if they sell it for 100, they can report a gain of 0. They don't have to report what dad paid for it. They only have to report what it was worth when dad passed away. It's called a stepped up basis. Whatever an asset is worth when you pass away. And if you're married, anything in your community property estate, when either spouse passes away, gets a stepped up basis, meaning capital gains taxes are wiped away as long as it's in your taxable estate. I'll talk in a moment about why that's a crucial term. So this wipes out capital gains tax exposure. Applies to stock, to real estate, to other investments. It's a pretty powerful thing, and a lot of people don't really understand that. Now, take one more moment just to introduce you to another key concept, the estate tax. Now, just again, I can't hear you. You can maybe put it in the Q&A function or whatever. How many families, what percentage of American families do you think are currently affected by the estate tax? Or how many family farms are lost? You see a lot of people arguing about, oh, family farms are lost to the estate tax. Do you think it's 5% of families? Do you think it's 20% of families? Do you think it's 50% of families under the current law? Just a moment, think about that. Feel free to put it in the Q&A or the chat, whatever you think it is, or comment if you're watching this as a recording. What percentage of people do you think are affected by the estate tax, also known as the death tax? Well, the reality is about 0.1 to 0.2% of families in America are affected. So it's 1 in about 1,000 families. Why? Because the exemption, the amount you can pass tax-free, is currently, and I mean currently, that's a crucial point here, $12.92 million. It's at a historical high. Now, of course, in Silicon Valley, even with this very high estate tax exemption, a lot of families are hit. It's a much higher percentage here. And in coastal California, Los Angeles, San Diego, Orange County. However, so you, unless you have, if you're a married couple, you can pass almost 26 million free of estate tax. Now, if you're single, it's up to about 13 million, but we have to be aware of the fact that unless major changes happen before then, on January 1st, 2026, the exemption is going to be cut by 50%. So it's going to go down to about $6 or $7 million per person. So your estate's hopefully going to keep growing in the next few years. Let's hope the economy turns around right as the exemption drops. And it's a punishing tax. Any dollar over the exemption amount is taxed at a 40% rate. So why is this all important? Because if you're a married couple, this has a huge effect on which trust structure is right for you, to AB or not to AB. That is the question. And sorry, I know that's so corny, I know, but I want to make these concepts really hit home for you. So I'm going to go through that. And this is really, really crucial. If you are married, and I'm going to go through issues that are relevant, whether you're married or not, later in this talk and other talks. But right here, if you're married, if you have a living trust you set up a long time ago, pay close attention here. This is crucial. Or even if you did it recently. So just to take it one step back, revocable living trust, everybody should have these. When you create a living trust, just a primer, you have settlers. This is the people who create the trust, or also known as trustors. You have trustees, the people who manage the trust. You have the trust, and you have beneficiaries. So a living trust, you are almost certainly the settler. You are almost the trustee or trustees, and you are also the beneficiaries as long as you're living. And then after you pass away, your kids are. Now, let's talk about an AB trust. By the way, just take a moment. I know this slide is a lot. I'm going to break it down step by step. Who here is familiar with an AB versus a non-AB trust? Do you understand the differences here? Because if you do, you might have a law degree, but it's not something most people understand. But I'm going to talk about why it's so important that you at least review it with an expert. And we, of course, can do that. So I'm going to talk about the different trust structures couples can have in place. So an AB trust is one of the two, broadly speaking, structures that couples can have. And when I say AB trust, this refers to what happens to the trust after the first spouse passes away. As long as both spouses are living, you can change the structure any way you want. You can change it every week if you wanted. But when one spouse passes away, that's where the AB structure really comes into play. So let's say there's a couple with a $6 million estate, and I know bigger number, but in California, that's a lot of families, but whatever your number is, these just use the same ratio. So let's say a $6 million estate, it's all community property. When the first spouse passes away, remember about that stepped up cost basis? The entire community property estate gets a stepped up basis. The surviving spouse can sell those assets, pay zero in capital gains taxes. Now here, if you have an AB trust, your assets are split. So 3 million would go into the A trust, the survivor's trust. 3 million would go to the B trust, also known as the exemption trust. Think of it this way: A above ground, B below ground. God, estate planning humor is lame, but that's how we often remember, even us attorneys. The A trust is under the full control of the surviving spouse. The surviving spouse can change its terms, change its structure, change beneficiaries, and then they have control of the money. Now, the B trust becomes irrevocable. The surviving spouse can't change its terms. But the upside, and that's an upside by itself. Some people like to know, hey, if I go first, I want to know that my wishes are locked into place. What if my wife gets remarried or something like that? It also gets permanent estate tax protection. Unless it's a very large estate, we'd have a more complicated structure. But in this case, that full 3 million is permanently taken out of the estate for estate tax purposes. So even if that grows to 10 million in the next few years, it's irrelevant. It's not going to be touched by estate taxes. That's a good thing. It's irrevocable. That is a good thing for some families. Now, why do we have to circle back to that capital gains tax issue? When the second spouse passes away, remember earlier I talked about capital gains taxes. You get a stepped up basis only if something is in your taxable estate. When the second spouse passes away, let's say the assets have grown in value. Let's say the wife outlives the husband by 5 or even 10 years. The value of those assets are probably going to grow. When the wife passes away, assuming she's the survivor, the assets in that A trust get another stepped up basis before it goes to the 2 kids. And it shouldn't go to the kids directly. It should go in trust. So I'll talk about that later. If the asset, so that's a good thing, right? And there's no estate tax exposure. Now, the assets in the B trust, however, when they go to the kids, they do not get another stepped up basis because they weren't in mom's taxable estate. They were taken out of her estate, put in this exemption trust. So here, I'll talk about this a little bit more, but really, if you have a smaller estate and you're not exposed to estate taxes, if you're under, and I'll talk about some numbers in a second, but if you're under a limit where we're not worried about estate taxes, well, taking some of the estate out in this B trust for estate tax purposes doesn't help you. You don't need that help. You're giving up on a second step up in basis. And that can be really crucial. Now, what's the alternative structure? Our firm calls it a continuing couples trust. You can also just call this a non-AB trust. So here, same situation, $6 million estate. One spouse passes away, full stepped up basis. Now we really have to administer the estate properly to capture estate tax protections. The trust continues. The surviving spouse has full control of the trust estate. And by the way, when the first spouse goes, we have to file for something called portability. So not an issue I'm going to focus on today, but don't just do this at home. You need to get expert help. But the trust here continues, $6 million in the surviving spouse's trust. It's revocable, and this is subject to estate taxes, but if it's under 6 million or so, and if we take the right steps when the first spouse passes away, we shouldn't be able to, even under the new law in 2026, we should still be able to protect 12 million. So we're not worried about estate taxes, but here the benefit of not splitting is that there's a full step up in cost basis when the second spouse passes away. Remember with that AB trust, only half the estate got a stepped up basis. Assets in that A trust, here, the entire estate gets a stepped up basis. So there's more issues we have to be aware of than just this. But if you have a smaller estate, and smaller, relative term, I know, smaller estate, the AB trust is probably not the right thing unless you have other goals. If you're worried about the irrevocable nature of it, if you want to lock in your wishes, different issues. But from a tax perspective, it might be the wrong structure. In fact, it most likely is. And if you did a trust a long time ago, well, you probably have an AB trust. And capital gains tax, because that's our primary concern for most of our clients. Did you pay under $100,000 for your home in the Bay Area or Los Angeles or San Diego? Raise your hand if you paid under $100,000 for your house. I envy you so much if you live in California, because it's probably gone way up. And so you have a huge capital gain, and that's a huge issue. So I think a general rule of thumb, and this is just for tax purposes, is that if you're a married couple and your estate is under $5 million, from a tax perspective, you don't want an AB trust. Now, if your estate grows or as laws change, we might go back to recommending an AB trust. But if you have one, we want to revisit that. Or if you're not sure, we need to revisit it. Contact us. We can look at it very efficiently. And let's go back to this tale. Remember, I teased this story. Larry and Susan have a $3 million estate, including their home. Susan outlives Larry by 5 years. The estate grows to $5 million after she passes away. Their children face over $300,000 in capital gains tax exposure. Wyatt and Jane, $3 million estate. When they pass away, zero capital gains tax exposure. Now, what's the difference? Well, Larry and Susan had an AB trust. So when Larry passed away, half the estate was put in this exemption trust. And when Susan, the second spouse to pass away, died, the assets that were taken out in that B trust did not get another step up in basis. So their kids were exposed to $300,000 in capital gains taxes. Wyatt and Jane, on the other hand, they said, oh, we don't need the AB trust. Let's simplify it. Full step up in basis when the first spouse passed away, and another step up in cost basis when the second spouse goes. All the assets pass for the benefit of their kids with zero capital gains tax exposure, saving hundreds of thousands of dollars. Now, on the flip side, larger estates. So remember, Ben and Ann have a $10 million estate. It grows to $16 million by the time they pass, or maybe it was $18 million. Their estate faces over $1 million in estate taxes. Jacob and Sarah, they also have a $10 million. Their estate also grows massively by the time that they pass. And Jacob and Sarah, though, have zero estate tax exposure. Now, why is that? Well, Ben and Ann, for them, because they had a larger trust, it made sense to keep the AB trust structure in place. When the exemption dropped on January 1st, 2026, well, Ben had passed away before that drop, and we were able to put assets in that B trust, permanent estate tax protection, and it made sense for them. Jacob and Ben and Ann did not use an AB, so they did not put the money in the B trust. So when the second spouse passed, the entire estate was exposed to estate taxes. They had $1 million owed. Jacob and Sarah switched to an AB trust, which froze part of their estate from estate tax exposure years before. And when the second spouse passed away, zero estate tax exposure. Even I get mixed up by all these terms. The bottom line is you don't need to understand all of the core issues I talked about here today, other than you need to understand what trust structure you have. And based on the size of your estate and your goals, we need to take a look at it. We can very efficiently help you with it. So if you're married with an AB trust, now should you keep it? I think a general rule of thumb, if your estate is under $5 million, at least from a tax perspective, you don't need an AB trust. If your estate's over about $8 million, you almost certainly should have an AB trust in place. Now, if you're in between, it's a gray area. We would talk about it and go through the trade-offs with you. And there are potentially hundreds of thousands of dollars in capital gains tax savings or millions in estate tax issues. So are you worried that you have a tax time bomb waiting to go off? Well, of course, let us review your trust. Now, I do want to flag, though, that it's not just about taxes, right? Life is more than taxes. Of course, we understand that. And even if you have a smaller estate, meaning still could be millions of dollars, an AB trust still might be right. Now, why is that? Well, what if you're in a second marriage? What if you have children from a prior marriage? What if you're just worried that, hey, if I'm older than my spouse, if I go first, I don't want my spouse to remarry and leave everything to this new family. I at least want to lock up part of the estate for my kids. So that's a case where, regardless of tax issues, you still might want an AB trust. But again, let us review your trust. You can easily find us gilfix.com, of course. We can go through these trade-offs with you. Many families, I'd say of the families we meet with, I'd say who have smaller estates, I'd say 60 to 70% who had AB trusts from before end up switching, but not all, because there's other situations involved. And this is why you need to talk to a counselor with an expert. Of course, we can help you with that. Now, this might be a small group of people, but if you are still around and if your spouse passed away years ago, and you had an AB trust and your estate was split years ago, and maybe your house was put in the B trust and it's gone way up in value, if you and all of your heirs agree, we can actually undo an AB split that was done years ago. So if you lost your husband or your wife years ago and you had an AB trust and you're worried about, oh my gosh, I could have all these hundreds of thousands of dollars in capital gains taxes, we can actually undo it. We can go to court and fix that sometimes. So the bottom line is, talk to us if this is an issue, because we work with families where everybody in the family had to be involved, but as long as everybody was on the same page, we were able to go to court, undo the AB split, even after one spouse passed away, saving families hundreds of thousands of dollars, not exaggerating. So the big picture, is your trust a ticking time bomb from a structural perspective? You created your trust many years ago, it's almost certainly an AB trust. If you're confused, that's it. If it's done years ago, if you did in the last few years, maybe it's not. If you're confused or overwhelmed by all of this, and it's a lot, I get that, talk to us. We can very efficiently go through your existing trust, tell you if it's an AB or not, and we can very efficiently go through the issues for you. And of course, easy to find us at gilfix.com. So leave a comment, leave a question if you're confused about this, or if you'd like us to address other issues related to this. Before we get on to our next subject, I'm going to get some questions at the end. We've gotten some good ones already. But again, contact us if you have questions. Don't try this at home. It's really nuanced. And really, every family is different. Your family is not the same as your next door neighbor or as your cousins. We want to look at it through the lens of your specific tax and family needs. It's not a one-size-fits-all approach. Living trust, is your trust a ticking time bomb? Living trust mistake number 2, failure to protect future generations, and really what you need to know. So this is the second big mistake we often see from people really who don't work with us, because if you work with us, we'd at least go over these issues, and some of our clients don't always do it up front. But I want you to take just a moment to think about all the sacrifices you made to leave assets for future generations. Now imagine all of that hard work and all those assets you've built up, all the times you decided to fly coach instead of first class, or to stay in the mountain view room rather than the ocean view room, or to get the chicken rather than the filet mignon, or all those decisions, all those investments you worked so hard for, the lucky investments, the not so lucky, all those steps you took to protect assets and to hopefully build a safety net for yourself and for future generations. Imagine all of that, or a big chunk of it, being lost to an ex-husband of your daughter, or to a lawsuit when your son or your daughter is sued, or to future estate or property taxes. A living trust, and this is where your living trust itself might not be a ticking time bomb, but thinking that it's enough, that could be a ticking time bomb, because your family could be met with some very rude surprises if they think that, oh, well, we have a living trust, we're good. Or dad's created a living trust, we're good. So I want to give just one more tale here. The tale of supercharging a plan. I'm going to decipher what happened here. This mystery. So Larry's father leaves him $2 million. Larry, during his life, endures a divorce. He gets sued after a car accident. None of this $2 million that was left for Larry is there for Larry's children. And of course, nothing's there for his grandchildren. So there's zero left. Wyatt, on the other hand, also inherits $2 million, or $2 million is left for Wyatt's benefit. Wyatt also gets divorced. Wyatt also gets sued. Same lives. Imagine parallel lives. But because of some different steps that Wyatt's parents took, Wyatt's children end up with $6 million from his inheritance, and his grandchildren end up with $18 million from that original $2 million left by Wyatt's parents. What's the mystery? And this is where we have to think about the power of compound growth, because money that's protected, assets that are protected, have the chance to grow and grow and grow. And if they're just invested reasonably, they can double every 10 to 15 years. And compound growth is a powerful thing. So you might start off with a number that doesn't seem massive, and it can become massive if it's protected. So I want to just take a step back. So we get these questions a lot. Quick overview on this. Now, this is oversimplifying things, but they're generally two categories: revocable trust or revocable trust, and irrevocable trust or irrevocable trust. The pronunciation always confuses me. My dad always says irrevocable, and I think it's irrevocable. I don't know. Do you think irrevocable or irrevocable sounds more logical? Either way, revocable means you can change it. Irrevocable means you can't change it once it's set up, or it's more challenging to change it. Everybody watching this video over the age of 18 really should have a revocable living trust. It's much better than a will. It really takes the place of what you think of as a will. Now, irrevocable trusts, there are hundreds of types of irrevocable trusts. There's no one type. Sometimes clients will call me and say, hey, I heard an irrevocable trust will protect my assets from estate taxes. It's like, well, some types will, but some types won't. So the point here is there's no one size fits all. Everyone should have a revocable living trust, but here's where your revocable living trust can be a time bomb, thinking that it protects assets for future generations. It does not. I mean, it provides some protection in the sense you put people in to manage your assets if you're incapacitated, but it doesn't provide divorce or lawsuit or other protections for future generations. It doesn't protect from massive property tax increases. So let's just make that point here. Revocable living trusts, whether you're a couple or single, do not protect your kids or you from divorce, from lawsuits. They can provide some protection from estate taxes depending on the structure, but not massive protections. They definitely don't protect from future property tax increases. So you're thinking, okay, well, Mark, that's great, but you keep telling me to do a revocable living trust. You definitely need it. But I'm going to talk about the additional tools you need to take your plan to the next level. And what can we do here? So this is about taking your plan from the floor to the mountaintop. That's a cool image, right? I kind of like this. So imagine right now, if you just have a very simple estate plan, hey, you're on the road, you're moving forward, but how do you get to the mountaintops? How do you get above what most families are doing? Because most families aren't aware of this. And by the way, if you're watching this right now, by definition, you're ahead of the game. You don't have to understand everything I'm talking about, but just by being aware that these tools are out there, you're ahead of the game. So share this with people in your circle who you think could benefit from this, because this is really powerful stuff. Okay, how can you protect future generations? Don't leave them anything. Don't leave your kids, your grandkids a penny, and that's how you protect assets for future generations. Done. All right, you can log off. No. Don't log off now, because obviously not leaving assets to the next generation, well, I guess they're protected from some protection from divorce and lawsuits because they have no money from you. But that's not what I mean. You should not leave them even 1 cent. Okay, I know, confusing. Instead, you should create a family protection trust for every one of your kids. If you have 2 kids, you should have 2 family protection trusts, aka Dynasty Trusts. You should not leave money to your kids. You should leave them to Dynasty Trusts, or our version, family protection trusts, for their benefit. There's no shortage of information out there about Dynasty Trusts. You can Google it, but this is really what ultra high net worth families have done for generations. And we don't think that's fair. We think every family, middle class, upper middle class, everybody should have the chance. Hardworking middle class families should have the chance to protect assets for future generations, not just the ultra wealthy. Now, the general term dynasty trust, I get why people are like, whoa, because what do you think of when you think of the term dynasty trust? You probably have an image sort of like this, right? Like a gigantic mansion. I'm not sure where that is, but I always joke that if this mansion is like in the Midwest, I don't think this is, it's probably in the UK or something, but if it was in like the Midwest, it might be less valuable than, a 3-bedroom house in Silicon Valley or in San Diego or whatever, because our real estate prices are still so crazy. But the bottom line is, dynasty trusts are not just for billionaires, although billionaire families have been doing these for generations. We can all benefit from them. Now, why is that? Well, there's 3 huge areas of protection. So if you're concerned about your leaving assets to your son or your daughter, and you're concerned about them getting divorced, well, assets, if you leave it to them directly and they commingle, 50% of what you leave them could be lost. If it's in a family protection trust, it's separate and it shouldn't be reachable in a divorce settlement. If your child is sued, if you leave money directly to them, it's fair game in a lawsuit. If it's in a family protection trust, there's a barrier of protection against creditors and people suing them. Now, nothing's 100%, but it's a heck of a lot better than having nothing at all. And this is really powerful. On the death of your child, and when assets go to your kids, and even on the death of your grandchildren, if you have these in place, the assets in the family protection trust, subject to some limits, are not touched by estate taxes. So let's say you have a child, maybe you're not leaving that much to your child, but your child's doing really well, and they have a pretty large estate. If they have a large estate and you leave them money directly, you just added to their estate, and everything you left them could be exposed to estate taxes. Or maybe estate tax laws change in the future. Maybe we have a Bernie Sanders type president in 5-10 years. I have no idea. I'm not a prognosticator, but it's possible. The estate tax exemption could drop dramatically. So even if you don't have a large estate, if you leave money directly to your kids, could get massively hit before assets go to your grandkids. If it's in a family protection trust, it is largely protected from estate taxes when your kids pass away and when your grandkids pass away, because here's the amazing thing. These trusts last for like 100 years. And you might think, okay, well, this is cool, but I don't want to tie my kids' hands. They're trustworthy. I think they can manage this. You can name your child to be the trustee of his or her trust after you're gone, subject to age limits if you want. So your child can control the trust largely for themselves and for their families, or really for themselves, and they can get all these protections without too many strings attached. It's really powerful. It can provide incredible peace of mind and protection for multiple generations. These last for about 100 years in California. So they can go for your kids, your grandkids, and even for your great-grandkids. And no, they are not just for the ultra wealthy. And you don't have to just take my word for it. Well, I guess it's sort of our word. So Michael Gilfix is obviously not here, but he just published an article in Bottom Line magazine. It's an amazing magazine that I read independently of this. And he wrote an article about the power of dynasty trusts and why families throughout America should really be putting these into place. There was recently a report on NPR. They talked about it, how dynasty trusts are how wealthy people, this actual quote from their segment on this, how wealthy people avoid estate tax, protect assets for future generations. And in California, again, these last for about 100 years, about 3 generations. It is not just for the ultra wealthy. You don't have to have many millions of dollars for this to be powerful. How much would you pay to protect your child from divorce, or at least protect what you're leaving? How much would you pay if there's an insurance program out there that would protect what you're leaving your kids from divorce and lawsuits, or provide a barrier of protection? How much would you pay every year for that? You'd pay thousands of dollars a year. You can set these trusts up once, and they can provide really extraordinary protections. So let's go back to that tale of supercharging a plan. Larry's father left him $2 million. He gets divorced. He gets into a lawsuit. By the time Larry passes away, 0 is left for his kids, and of course, nothing for his grandkids. Wyatt, on the other hand, that $2 million, by the time Wyatt also gets divorced, Wyatt also is sued. Same, imagine parallel life to Larry, same type of life situation. But when he passes away, $6 million there for his kids, and $18 million for his grandkids. Why? Because Wyatt's father created a family protection trust and didn't leave a penny to Wyatt. He left it to a family protection trust for Wyatt's benefit. So when Wyatt got divorced, those assets were separate. They weren't commingled. They weren't lost in a divorce settlement. When Wyatt was sued, the person suing him saw that trust and said, I'm going to settle for pennies on the dollar. I'm not going after this. All that money was able to grow. It was invested reasonably. He used it to support himself, but it was still able to grow. It was $6 million by the time he passed. The trust continued through his children's lives. They were protected from divorce and lawsuits, untouched by estate taxes when it went from his kids to his grandkids, and it had grown to $18 million at that point, untouched by estate taxes. So that's where you have to think ahead. But this is why I talked about this 100-year trust. It's so powerful. And I hate to say it, but the families that are creating these now, when you look at generation or 2 generations ahead, they're going to be so far ahead of the families that don't create family protection trusts right now. And again, don't need to be ultra high net worth, and we don't want you to be left behind. And again, these need to be separate from your living trust. Once in a while, I'll see clients, and they have a trust from a while ago, and they say, oh, well, I have this terminology embedded in my living trust. So when I pass away, it sort of goes to these dynasty trusts for my kids. There are a lot of reasons why we do not believe that's a good approach. It should be separate entities, separate documents. You have your living trust, and you don't leave it within your living trust with Dynasty's trusts within that. It should be separate for every kid. There should be a separate family protection trust. And of course, we can work with you to protect your assets for multiple generations at gilfix.com. And if you set one up a while ago, we should take a fresh look. Make sure the trustee structure of that is good. Make sure that your overall plan is good. But if you don't have this, don't get left behind, or spread that word to any. If your parents haven't done this for you, or your grandparents haven't done this for your parents, spread the word. Let them know about this, because it's the kids and really the grandkids who will benefit massively from this. So, and part two of this. Okay, so you need to have a family protection trust. You don't need to be ultra high net worth to have that. And your trust is a ticking time bomb if you think that your kids are protected just by having a living trust. They are not. You need to add these. So part two of this. Is your trust a ticking time bomb? This is the other mistake, thinking that your trust will protect future generations from lawsuits, divorce, estate taxes, or from property taxes. So we need to be aware of Prop 19 in California. Could there be 1,000% increase in property taxes for your kids, for your home, for rental property, if you happen to have that? If you watch our talks, you know we talk about this all the time. You might be thinking, God, Mark, I get it, Prop 19, it's a problem. We keep talking about it because you might be aware of it. 95% of families in California, I promise you, are not aware of this issue. It's just not out there. So it's our mission to educate people about what this law means, and of course, what you can do about it. So Prop 19, what is it? It's a new law. It became law in 2021. It was passed by California voters, and it guts property tax protections for your home for future generations. And I think one key area of confusion about this, and we saw this misstated in articles throughout the media, is a lot of people thought, okay, well, Prop 19, it has some good things, lets you move within the state and keep low property taxes if you're over age of, I think, 55 or 60. That's not our focus here. Our focus is what happens when mom and dad pass away, or when they transfer assets, transfer that home or that rental to the next generation. And a lot of people thought, oh, well, okay, I get that maybe rental properties are no longer protected from reassessments. The Prop 13 protections are gone for that, but my home, that's safe, right? Wrong. Prop 19 provides limited protection for your primary residence and zero protections from reassessment for rental property, or if you have a cabin or a vacation home or business property. So Prop 13 still exists. As long as you're around, your property taxes won't spike up, but for the next generation, they get hammered. And I think one key issue here is a living trust will not protect your family from massive property tax increases. Let me repeat that. A living trust will not protect your family from massive property tax increases. So that's another area where I think your living trust could be a ticking time bomb, because a lot of people think, oh, I have a living trust. It's safe, right? I've heard this from new clients. Well, I thought putting my house in a living trust meant there'd be no property tax increases when it goes to my kids. So I'm going to give a couple examples of how big these increases can be. So just some specifics on Prop 19. And if you want to learn more, by the way, we have a bunch of talks on our Gilfix Law YouTube channel. So go to YouTube, search Gilfix Law, subscribe. It's growing every day. I love it. And we have actually a few thousand views of some of our talks about Prop 19. And look for one of our talks is Prop 13 over. What Prop 19 means. I think we have a few talks there, and then we have a playlist all about this. So if you want to learn more and details about it, check out our YouTube channel. But at a high level, your primary residence, let's talk about the two categories. For Prop 19 now looks at your property in two categories, your primary residence and everything else. Your primary residence gets some protections from property tax reassessments if your children move in to your primary residence within 1 year of you passing away. So if your kids inherit your primary residence, your house, and they don't live in it, they just rent it out, full property tax reassessment. Now, if they move in, there's $1 million in fair market value that's protected from a reassessment. So let's say you have a $2.2 million house, fair market value, and the assessed value is only $200,000, right? So if your kids move in, you take the $200,000, you add $1 million to that, $1.2 million is not going to be reassessed. But hey, the house is worth $2.2 million. That leaves $1 million unprotected. $1 million will be reassessed. Property taxes go up by about $12,000 a year. And if your kids don't move in, well, the full $2.2 million is reassessed. All other real property is fully reassessed when you pass away, no questions asked. unless you take steps to plan, by the way. Rental property, business property, vacation property, you have a fourplex, a duplex, whatever it is, you're not living there, it will be fully reassessed at fair market value when you pass away, which often means the property will have to be sold. That's why Prop 19 passed, by the way. The Realtors Association was the biggest funder behind the campaign to pass Prop 19. Why? Because they knew it would result in hundreds or if not thousands of more property sales every year in California when families get that sticker shock of a property tax bill that goes up by 5x, by 10x, by 20x. And yes, we've seen that. But we have a solution. We have developed solutions for families. We have the Gilfix and Lepole and Dynasty LLC process. So we can solve this, but you have to plan ahead. And we know that the family home is more than just a structure, right? It's where you live. It's where you grew up. It's where you made your family. So it's not just about taxes, it's about preserving your home, right? And I just want to give a quick example. So let's say that we have a $3.3 million value home. And I know it's a big number, but in many parts of coastal California, from San Diego up to through the Bay Area or Marin, that's not always that big a house, which is crazy as a home buyer at my age. It's brutal, but that's the fact in California. So let's say there's a $3.3 million value home and a $300,000 assessed value because mom and dad bought it decades ago. So Prop 13 kept the assessed value very low. Let's say the child inherits it and a child moves in. They live in it. We thought we were protected, right? In this case, the first $1 million protected, but the house is worth 3.3 million. So you take 300,000, add $1 million to that, 1.3 million, that's protected. That leaves $2 million unprotected from property tax increases. So the difference, if a family does Prop 19 planning and keeps those property taxes low versus not taking steps to keep property taxes low, look at the numbers. They go up about $22,000 a year. And over time, over 10 years, that's $240,000. Over 20 years, over $500,000. Over 30 years, almost $900,000 extra property taxes. And property taxes are not fully deductible from income taxes. So to pay that extra $892,000 in property taxes, your child would have to earn 1.4 million extra dollars just to pay those taxes. So yeah, planning ahead can be so powerful. We're talking about hundreds of thousands of dollars, if not millions of dollars for future generations, if you understand this issue and take steps to plan. So again, is your trust a ticking time bomb? If you have a rental, do you have a child with special needs and you're hoping that rental will support them? Prop 19 has zero protections for rental properties. So no matter what the rental property, unless you take steps and work with us to protect it, it would be fully reassessed at fair market value. And, again, let's say it's a $2 million rental property with a $200,000 assessed value, similar numbers, by the way. If for a family that takes steps to plan versus not planning, we're talking about over $200,000 in after-tax money that you have to spend on property taxes over 10 years, over $800,000 over 30 years. Now, imagine if you have a child with special needs or you're worried your child won't be able to get a job because AI is taking over everything. That can be the difference between having a sustained future and not, right? It's a massive difference. So imagine what we can do when we work together to save your hard-earned real estate. And I'm not going to spend too much time on this, but we have helped hundreds of California families to protect their properties, their primary residence and other properties from property tax reassessments. And we can still lock in the crucial step up in cost basis that we've talked about in other talks and earlier here today. There are many techniques using LLCs or entities where we can fully legally protect properties from reassessments. And if we use sophisticated trust planning as part of that, we can often still get a crucial step up in basis. So you don't want to give away your properties now. You don't want to use entities and immediately give it away to your kids. Don't try this at home. Do not work with somebody who does not understand these issues inside and out. And fortunately, Francis Lepole on our team is, I think, one of the best tax attorneys in America, and he has developed some extraordinary solutions. There's no one-size-fits-all solution for any family. It depends on the size of your estate. We have to weigh estate taxes, property taxes, capital gains taxes. But we have already helped hundreds of families in California. Of course, we can help you. So if you know somebody who needs to understand this, your parents, right? Your grandparents, spread the word, send them our talks because you might be the one who gets hit with this property tax increase. We've had many kids of clients come in and actually pay for the work to protect mom and dad's properties from property tax reassessments because they're the ones who save, who really benefit from it. So, okay, do not assume your living trust will protect from property tax increases. It will not. Talk to us if you want to protect your assets and your property for future generations. At Gilfix.com, obviously easy to find us. Okay, I'm not going to spend too much time here, but the Gilfix Law mistake, living trust mistake number 3, failure to protect a child with special needs. So this is a big one. If you watch our talks on special needs planning, Michael Gilfix and I co-authored this book, Special Needs Trust Creation and Management Guide. It is available on Amazon. It's available to our clients. But you have a child on the autism spectrum, substance abuse issues, mental illness, physical impairment. And we have a slide where we show just a sampling of the different diagnoses our clients' children have had that resulted in a disability. It is crucial that if your child will have any inability to work after you're gone, that you do not leave money directly to them, that you work with an expert to create a separate special needs trust. And again, our book goes through how we think about this, but you don't want to leave money directly to them because they lose government benefits eligibility in many cases. And can they manage that money? Are you worried they can be taken advantage of? Are they able to manage it? So special needs trust really solves both of those issues. And you can probably relate to this. If you have a child or a loved one with a disability, a diagnosis changes everything. So again, if you've had a diagnosis in your family, you need to create a special needs trust. It needs to be part of your comprehensive estate and financial plan. Your living trust will not protect children and grandchildren with disabilities unless you add a separate special needs trust. So it has to be part of a comprehensive plan. And again, you do not, in this case, you don't leave money. Let's say you have a child with a disability. You do not leave money directly to that child. Instead, you create a separate standalone special needs trust for that child. Here it's Sarah. So mom and dad would not leave money to Sarah. They would leave it to a special needs trust, ensuring that someone they trust, a third-party trustee, oversees it for Sarah and that the money doesn't count against public benefits eligibility. So again, not the focus of this talk. We have plenty of other talks on the Gilfix Law YouTube channel where we go into this in more detail. But this is where it can be a time bomb. If you have, is your living trust a ticking time bomb? Well, you have a child with a disability and you have not created a special needs trust, or you created one a while ago and you think it's fine, you need to revisit it. The key thing here is if you name the right trustee, who's going to step in when you step in, who's going to step in and oversee those assets for your child or your loved one to make sure they're not taken advantage of, to make sure that money is invested well, to make sure they're protected. Do you have an integrated legal and financial plan in place to make sure that your beneficiary designations are coordinated, that your investment approach is right? We're developing an integrated legal and financial program for select clients. Talk to us about that. And of course, don't work with somebody who dabbles in special needs planning. We work with hundreds and hundreds of families. I think we're the second firm in the state of California to do special needs trusts before they were even known as special needs trusts. And I'm very proud of our history in this area. But talk to us at Gilfix.com. It should not be embedded in your living trust. If you have a child with a disability, you do not want to have a living trust that has sort of a few paragraphs about how when I pass away, money will be held in this 5-paragraph structure for the rest of my child's life. That can lead to all sorts of problems, and it's very hard to update. So it should be a separate standalone document. Talk to us. Reach out to us at Gilfix.com if you have questions about this or if you need to put a special needs trust in place. So I can't emphasize that enough. Your trust is a ticking time bomb if you think it'll protect your child with a disability. It will not. You need a separate special needs trust. And I've just a couple more subjects and I'll get to some questions. Some really good questions here. So the last mistake. So the Gilfix Law, is my trust a ticking time bomb? Living trust mistake number 4, a failure to update. What you need to know to ensure that your trust is not that ticking time bomb. And let me just say this, an out-of-date living trust can be worse than no trust at all. And I know we hammer this. Everybody needs a living trust. Everybody needs an updated estate plan. Updated estate plan. If you have one that's way out to date, there are cases where it can be worse than no plan at all. I want to tell a quick story about Heath Ledger. Heath Ledger, one of my favorite actors of the last 30 years. You know, raise your hand if you were a Heath Ledger fan, right? Who saw his legendary performance in The Joker? I mean, that is arguably, I was a professional actor before I was a lawyer, so I was nowhere near as good as him, but it gave me a special appreciation for good performances. And his performance as the Joker was next level, right? Like, I don't have to see you, but raise your hand if you think Heath Ledger gave one of the best performances in the last 50 years. But really tragically, he died of a drug overdose in 2008. And when he passed away, he actually had a simple estate plan in place. But here's the problem. He had not updated his documents in 2008. He last updated them years before his daughter was born. So when he passed away, there's millions of dollars in his estate. His daughter got zero, because he set a plan, leaving it to the wrong people. He didn't have a kid yet. He didn't allow for that. He didn't work with somebody who knew what they were doing. We often can say, well, if I have a child in the future, we'll go to that child. And it ended up, I think, working out from what I read. The family worked together and they redirected assets. So it did eventually go to his daughter. But if there was someone who did not have a relationship with his daughter who inherited, that money could have been lost forever. So how is that relevant for you? Well, we need to understand you need to update your estate plan when your situation changes, as laws change. And I think this is also a really important point. The documents that you create will govern what happens, even if they are illogical under the new circumstances, and even if they're obviously counter to what you would have wanted at that time. If you created documents 20 years ago and named somebody you now hate as your trustee or don't trust, maybe they're in prison now, you name them, they're still named. If you don't update it, you're empowering the wrong people. So it's so crucial to update your estate plan every few years. And here's a little checklist to make sure that your plan is up to date. First question I would ask is, have you reviewed your estate plan in the last 5 years? If the answer is no, probably time to take a fresh look. Of course, we can help you. Do you have new children in the picture? Do you have new grandchildren in the picture? There have been cases where we had clients who named specific grandchildren, they pass away, and they just forgot to make an update. So both of their grandkids got money. The new ones that were born after they updated the trust got zero. Or they didn't have the right trust structure. Do you have the right trust structure? An AB or non-AB trust? We talked in other videos earlier here today about how it can have hundreds of thousands of dollars in tax implications, even if you don't have a large estate. If you have wrong non-AB or an AB, depending on the size of your estate, that might cost your family hundreds of thousands or millions of dollars. Trustees, this is huge. Have you revisited who you named as trustee in your trust and your other documents? Do you even know who you named as backup trustees? I've had meetings with clients in the last month where the person they named as their first trustee, they are now embroiled in litigation against that person because they were friends when they created the documents and they are not friends anymore. And that is a disaster. Just because you're in conflict with that person doesn't mean they're not empowered to step in and manage your entire financial life if you name them as trustee. More importantly, do you have the right backups? Are you going to be covered? The person you name, are they sick now? Are they just overwhelmed? Are they going to be able to serve? Have you talked to them about this? So revisiting trustees regularly is so, so important. And have you set up structures to protect future generations from divorce or lawsuits or property tax increases or estate tax problems? So if any of these issues strike you as, ooh, I don't think I've done that. Hey, let's set a meeting. It's easy to review these issues very efficiently if we do it. But even if you don't end up working with us, you need to update these documents, and it has to be with an expert. And of course, we want to make sure that your estate plan empowers and benefits the right people. Have your children's situation changed? One of your children crushing it financially and another is really struggling. Maybe you want to redirect where assets are going. Is one of your children facing a new disability that they didn't have years ago? Do we need to add a special needs trust or other protections? Is one of your kids getting divorced and you're freaking out about what might happen if you leave money to them in the near future? Could that be lost to the ex-spouse? There's so much that we can do. And if you work with us before, we can take a fresh look every few years. I have some clients who come in every year for review. We have something called the Peace of Mind program for existing clients. Some clients check in with us every year. Some clients come in every 3 to 5 years. Some clients, literally, I saw some in the last 2 weeks. The last time they'd worked with our office was like 2001. And probably time to take a fresh look. So easy to find us, of course, at gilfix.com. Now, let's get to the conclusion here. So is your trust a ticking time bomb, and should you meet with us? Again, four key questions to ask. Do you have an up-to-date estate plan, or has it been more than 3 years since you last reviewed it? 2, do you have a home or a rental property in California? Do you want to leave it for future generations? Okay, let's address that Prop 19 issue. Are you concerned about property or capital gains or estate taxes? Do you have the right trust structure? Are you aware of estate tax issues? We can very efficiently help you understand those or take the steps that you need to take. And do you want to protect assets for future generations from lawsuits or if you have a child with special needs? A living trust is not enough. That's where it can be a ticking time bomb, thinking that it is, or having an out-of-date living trust. And our team is not just me, by the way. It's Nick Klingenberg, Renee Conrad, Michael Gilfix, and Francis Lepole are two principals. And we have over 120 years of combined experience between the five of us. And I think it's actually significantly more than that. Over 120 years of estate planning and elder law and tax planning experience. So we all work together. And for those of you who haven't, you can just point your phone at this slide. Subscribe to our Gilfix Law YouTube channel. We have over 60,000 views of our little videos. I'm very proud of that for a estate planning law firm in California, over 60,000 views, and we're growing every day. So spread the word. And I'm also doing a Mark Gilfix channel on YouTube. You can find me, just go to YouTube, search Mark Gilfix. I'm just doing 60-second videos, a lot of quick tips. So you don't like long videos, subscribe to the Mark Gilfix channel. I just got that started. I'm starting to get, if you subscribe, I have over 10,000 views on my Mark Gilfix channel. So check that out as well. But most importantly, just imagine what's possible when we plan together. And of course, we would love to be part of your team now and in the future. We encourage you to meet with us. You can contact us at 650-493-8070 or gilfix.com to find more. Wow, we just did this under an hour. So contact us at gilfix.com or just reach out. If you're an existing client, let's meet again. If you're a new client, hey, let's set that planning meeting. We can typically talk to you for a few minutes before setting a full meeting to make sure that you're a fit for us, we're a fit for you. But reach out. Don't let this drag. And I'm going to get to some questions in just a moment. But if this was useful, please leave a comment or a question or anything you'd like us to address. Spread the word. Share this with someone in your circle who could benefit from this. And if you're a child or you have a parent who's leaving assets for you in the future, get them to watch this, get them to come in, because you're going to be the one who will face that massive property tax increase or might have assets that come to you unprotected. So talk to your parents about this, your grandparents. Spread this. We've had many clients come in recently who said, hey, I shared this webinar with my parents and that got them to call you. So I hope you got a lot out of this. I'm going to get some questions right now. So we have a good question from Brent. How is an irrevocable trust enforced? So there's a while ago where we talked about irrevocable versus revocable trust. The way a trust is enforced is really just based on the terms and the trustee named to oversee it. So it's a very broad category. So there's no one way that an irrevocable trust is enforced. But let's say you have an irrevocable trust and your family's like, we don't like this. We're just going to change it up. Well, if the IRS, if this is for tax planning, if the IRS sees that you violated the terms of the trust, you could face massive tax penalties. So it's really kind of enforced after the fact. You could screw up the management of an irrevocable trust while you're doing it, but then later the IRS will hit you or you could get sued. So there's no one who watches over a trust day in, day out, or the trustee does, but that might be a family member. If they screw it up, you don't know right away. There's no trust police who watch it. It's later you get hit. Kind of like if you cheat on your taxes or screw up your taxes, you get audited and you can get crushed later. Is there an easy way? Another good question from Brent. Is there an easy way to recognize what type of trust I have? Is it an AB or not? Not to a non-attorney. Different. I see a lot of different trusts created by other firms, and even I get confused sometimes. Generally speaking, there should be something about what happens to the trust when one spouse passes away. You can look for that. But even then, it can be confusing because sometimes trusts have these things called contingent disclaimer trusts, which are not necessarily AB splits or not. So even we as attorneys sometimes have to take a good amount of time reviewing. But largely speaking, if you created your trust many years ago, if you're married, there's a good chance it was an AB trust. But the bottom line is it really needs to be looked at by an expert. And we, of course, can review it at gilfix.com and take a fresh look. A good question and again, it can have huge implications from a capital gains and capital gains and estate tax perspective. Good question from Neil. If you have a special needs trust, do you need a family protection trust? So good question. And so let's say if you have just one child and that child has special needs, you would not need both. You would just do a special needs trust. But let's say you have two kids and one child has special needs and the other does not. Well, the child with special needs, you would create a special needs trust. You leave assets to that. The child who does not have a disability or special needs, you create a family protection trust. So we have many clients who are, 3 kids, 1 special needs trust, 2 family protection trusts. So good question. And let's see, well, a lot of good ones. A question from Bob about, are we licensed for practice in Washington? And unfortunately, we're not. If you do have questions about Washington law, we have a good network. You can always check the NALA, National Academy of Elder Law Attorneys, NALA.org. Michael and Myra Gilfix, my parents, are founders of NALA. It's the preeminent organization for elder law attorneys in the country. And we also know some attorneys in Washington State. So you can contact us and we can try to refer you to someone really good there. So we have a question about fees to create trusts. Good question from Mr. Mendelson. So it varies, so it depends on your situation. The way that we structure fees is our initial planning meeting, we bill hourly, because we are there to serve you from day one. Now, if you haven't worked with us before, we're often happy to do a 15-minute call ahead of time to make sure you're a fit with us. The initial planning meeting, we typically bill hourly, and then we have flat fees for documents. And living trusts can be anywhere from $2,400 to $3,500 depending on your structure. Special needs trusts typically around $3,100, $3,200. But different trusts have different fees, and it really depends on your situation. I hate to say it, but our job is that we don't do things as a cookie cutter, and we always tell you ahead of time what the cost would be before you commit to it. And usually we can show you why it's a no-brainer to do what we recommend. Some of the planning tools we put into place can save millions of dollars. And the cool thing is you only pay for these like once. Now you might update in the future. You put these into place, and unlike a financial advisor or insurance, you're paying them every year to keep policies in place or to manage it. For what we do, while you can certainly meet with us every year, many clients do as part of our Peace of Mind program. You don't have to keep paying to recreate these or to maintain them every year. Once they're in place, they can be extraordinary. If we're doing Prop 19 property tax planning, it can be quite a bit more than that because it's just a lot of work. Or estate tax planning can be more than that. But again, you only do that if it's a no-brainer from a return on investment standpoint. We can show pretty extraordinary returns on investment. So we have some questions about could someone adopt an adult so that surviving adult can get the $1 million protection for Prop 19? And what are the chances that this new proposal in the legislature can make it through to restore the earlier rules before Prop 19? So for the first question, yeah, you could adopt somebody. I would say it's probably easier just to do some planning with us rather than adopting somebody. But yes, if you adopt somebody, and if they live in the house after you're gone, that's one way to do it. Marrying somebody, that's another way to do it. Prop 19 doesn't affect married couples. So we have some longtime couples, they're not married and they want their significant other to be able to stay in the house after they're gone. Well, if they're not married, full property tax reassessment. If they are, zero property tax reassessment. Now, when it goes to kids, there could be a reassessment. Now, as far as Prop 19 getting overturned, I have no idea. It takes a lot of steps to overturn something passed by voters. I think it's very unlikely. And as I was a management consultant before I was a lawyer, and we used to say, hope is not a strategy. Do not wait for, if there's anything we know, right, it's that politics are impossible to predict these days. I have no idea what's going to happen in the next few elections. So we don't want to rely on laws changing. And if you do planning steps to protect your properties and the law does change in a favorable way in the future, well, you're not going to be worse off. But if you don't do planning and you're waiting and praying that laws get overturned, if they don't, or if they get overturned after you pass away, there's a good chance your family could be stuck with hundreds of thousands of dollars in extra property tax increases. So when in doubt, think of this type of planning at worst as an insurance policy. It almost certainly will pay off, but if not, hey, it's an insurance policy to preserve your properties because the stakes are so high. That's why to us, most of the families who really dig into this with us move forward with sophisticated planning. I'm going to take just one more question. So many good ones. So I own a home that has an AB basis from my parents. Will it get totally stepped up when I die or only part? So whatever your parents had is irrelevant once it goes to you. Once the second parent passes away, you inherit it, and whatever the cost basis is, it is. If there was an AB trust, maybe you didn't get a full step up when the second spouse passed away. Once it's yours in your name, as long as it's in your taxable estate, when you pass away, your kids will get a stepped up basis. But here's the thing, if you have a parent and one of your parents has passed away and your surviving parent lives in a house that's gone up a lot since the first parent passed away, talk to us, because if they had an AB trust from years before, we might have that ticking time bomb. You might face hundreds of thousands in capital gains taxes if you ever sell the house, unless we undo that AB trust. And we can undo it. We work with many families. We have to go to court, and everybody in the family has to agree. But we can undo AB splits that were done even years ago, if it makes sense. and if everybody's involved. So just talk to us if you have a specific situation. But that was a lot. So many. I have more and more, excuse me, more and more questions. But again, I hope everybody got a lot out of this. That was a lot. But again, if you got something out of this, please spread the word, subscribe to our Gilfix Law YouTube channel. We're posting this, and we break these up into short videos as well. So it won't just be this long video. We're gonna have short versions as well. So I hope you got a lot out of this, and I hope everybody's staying safe, sane, and healthy. I hope everybody takes care. See you later.